I want to welcome everyone to the week 2 live video, and we're going to be discussing as the authors state in the heading for the chapter, a duty of loyalty. And what we're going to be discussing are two legal issues that have affected employment, and especially in recent times, the concept of whistleblowing and employment at will. Now, the American labor movement has been controversial, has been contentious. Around the turn of the century, there were actual labor riots. Management sent out individuals to beat up the labor union members who were striking, and it's been a difficult period. And we have understood that the law has pretty much stayed the same. There has not been much change in employment law, and the basic understanding is the concept of employment at will. Now, some of you may have heard of this or been familiar with it. Maybe you're hearing this for the first time, but employment at will as a legal concept is the idea that an employer can terminate an employee without notice, without reason. They can be terminated immediately, and the employment is ended. The employee has to leave the area of employment. Many individuals think that the law requires that the employer give the employee notice, when in fact that's not true. Some employers do give 2 weeks notice, but that's merely for the convenience, and really it's at the discretion of the employer. The other side of the employment at will concept is that, of course, an employee can leave without notice. So if you're disgusted with your job, you've had it with your boss, you can give notice. You can immediately contact the boss and say, I quit, I'm out of here, send my check to this address, and you can leave without giving any notice. And in both situations, the employer and the employee have no liability to the other party. Now, the authors combine these concepts of whistleblowing, and let me explain what we mean by whistleblowing. The definition is that an employee has discovered the employer is conducting something illegal. There is some ethical or fraudulent activity going on. The individual reports it to his or her superiors, and because of that, the employee is terminated. And this is usually what happens. The whistleblower is fired and loses their employment. So that you have to be very courageous if you're going to be a whistleblower. And the idea that you're really putting your job on the line for doing that. In the first case, illustrates what we're talking about as this concept of how whistleblowing and employment at will kind of go hand in hand. And Don Milton was a individual who worked for a Research Institute, this IIT Research Institute. And most of the work that the Institute did was tax-free. There was no tax due because the work of the institution was for a public good and a benefit, and therefore it was like a charity where the income is not taxed. At some point, Mr. Milton discovered that, in fact, some of the activities of the company involved taxable work, and that they would be liable to the IRS for receiving this income and it not being taxed. Mr. Milton went to his boss, explained what was going on, and suggested that someone needs to take a look at this. His boss's reaction was he fired him. And so Mr. Milton filed a suit for wrongful discharge, and that's the legal term we use for someone that alleges that they were terminated from their job for without any cause or without a legal basis. The court looked at Mr. Milton's arguments and determined that he owed no legal duty to his superiors to report this tax problem, that he had no legal duty to report it, and therefore his termination was legal and valid, and the case was dismissed. Now, when we're talking about employment at will, we want to understand that there are some exceptions to the employment at will doctrine, that you can be terminated without notice. One important exception is if you're working for a company that has a union. The union negotiates the salaries, the wages, the benefits, everything for the employees. They represent the employees collectively in any decisions with management. So if you are under a union contract, you cannot be terminated without notice. The union has certain requirements that the employer has to follow before an employee is terminated. So that's one exception. The other important exception is the concept of discrimination. And under the Constitution, as you know, there are certain classes of people that are protected from discrimination. And those characteristics are race, national origin, sex, age, and disability. So that anyone who alleges that they are being terminated, being fired from their job based on discrimination in one of those protected areas, they would be protected from a wrongful discharge. And of course, they'd have to prove where the discrimination is before they'd be able to prevail. Now, as part of this discussion I mentioned how really the relationship between employers and employees has been a controversial subject, has led to many lawsuits. The table on page 41, and this is a little dated, it's from 2005. This is an Ethics Resource Center survey. And what's interesting about this survey is 3,000 employees were interviewed, and they were asked to list the types of misconduct they've noticed while working for the company they're employed with. And you'll notice, number one, abusive or intimidating behavior toward employees, 21% have observed that. Lying to employees, customers, vendors, or the public, 19%. Putting employee interests over organizational interests. I assume that probably means favoring certain employees. Violations of safety regulations, misreporting of actual time work. 12% saw discrimination, 11% observed stealing, and 9% observed sexual harassment. So if we can gather anything from these statistics, is the workplace can be very difficult and for employees. And we have another case, Pierce versus Ortho. And again, this involves a whistleblower who was terminated after they approached their bosses about a problem with some operation in the business. Now, you're probably familiar with Ortho. Ortho is a drug company who has many medications and develops drugs for certain kinds of illnesses. The plaintiff in this case, Dr. Pierce, was in charge of a program to develop a new drug to prevent diarrhea in infants. And it's important to point out, Dr. Pierce was an employee at will and therefore was not under any of the exceptions that we previously talked about. Dr. Pierce, in her studies, from the research she was doing, discovered that the drug being proposed had a large portion of it contained saccharin. And saccharin is an artificial sweetener, a substitute for sugar. And also Dr. Pierce discovered that this could be harmful to infants, that the saccharin could affect the health of these infants that they're trying to treat. She approached her boss and objected to the continued development of this drug. And she met with the senior officials in the company and expressed her concerns at this meeting. After the meeting, her boss advised her that she would no longer be the head of the project, that she was being reassigned to another area, and she'd have no more involvement with this project. Dr. Pierce resigned and filed a lawsuit for wrongful discharge. The court examined the facts of the case, and she had an interesting argument. She argued, as a doctor, she was under the Hippocratic oath that she was to do no harm to patients, and that she was violating a legal duty that she had to her patients. The court dismissed this argument, saying that that really was no legal duty and that she could be terminated or could be removed from the project if in the employer's discretion. So again, we have another whistleblower who ends up losing their job because of their informing the bosses of some illegal conduct in the company. Now, an interesting feature that the authors give you, and as far as I know, this is the only state in the United States that actually has a statute that covers wrongful discharge. And believe it or not, it's Montana, which is kind of surprising. But the Montana legislature felt like this was important enough that they passed a statute that covers the area of wrongful discharge. And if you notice in the statute, it gives the various elements of a wrongful discharge, provides the employee remedies in the event of that, and even has some exemptions under the statute. So as far as I know, Montana is the only state in the union that has such a statute. So it makes it unique. Now, the authors discuss the Enron case, and hopefully you're familiar with the Enron Corporation and what happened with the conduct of their business. Enron was an energy company located in Houston, Texas, and Enron had a lot of assets in natural gas. They owned pipelines to deliver natural gas throughout the country. They were involved in electric production and the delivery of electricity to various areas of the United States. Well, at some point, we're not sure who came up with this bright idea. The principals, the managers at Enron, the chairman of the board, and CEO and other top officials at Enron decided they'd come up with a scheme to improve the profits of the company. And so they literally started misrepresenting and filing false income statements that represented these profits that didn't exist and showed Enron to be a very profitable company. It got a lot of publicity through the press, and of course Wall Street noticed that they were very profitable and productive, and of course their stock increased based on these income projections. They were all false. This was a fraudulent exercise. Finally, at some point, the company collapsed. It filed bankruptcy, resulting in the largest bankruptcy in United States history. The principals of Enron were charged, were prosecuted, and some are still serving prison terms, some received long prison terms. The chairman of the board, at the end of his trial, and while they were awaiting sentencing, he collapsed and died of a heart attack. So his was he received the ultimate penalty for the fraud. Now, the whole point of this is Mrs. Watkins. And Mrs. Watkins was an auditor for Enron. And she was a whistleblower. And she approached the chairman. She went right to the chairman of the board and reported this activity to him. Well, of course, he was involved in the fraudulent activity. And so when she reported it to him, she obviously was, nothing was going to happen as a result of her informing him of this activity. She discussed it with the other major individuals in the corporation and was pretty much rebuffed, was pretty much ignored. She became very frustrated and eventually resigned from the corporation. She appeared in congressional hearings and stated very forcefully what she had observed and that she was pretty much ignored. At the same time as the Enron failure, many other corporations had also been conducting fraudulent activities to falsify their profits and to increase their stock value. And Congress, because of this, passed legislation called Sarbanes-Oxley, and it's abbreviated SOX, as you see on the PowerPoint, and it was passed in 2003. And Sarbanes-Oxley protects whistleblowers, and this is the first kind of legislation passed by the federal government. And what Sarbanes-Oxley does is, if you are in a large corporation and you have information that there is fraudulent activity going on, a false reporting of profits, and you report it to the authorities or to your bosses, you are protected from retaliation or wrongful termination, so that you have the protection of federal law and to report this illegal activity. One of the criticisms of Sarbanes-Oxley is it's limited to an individual who is a whistleblower who is reporting fraudulent financial statements of corporations. It doesn't apply to any other whistleblower situation. So it is a very limited statute, but it is the first where the federal government has recognized the importance of whistleblowers and how they can do a service to the public. Now, the authors conclude Chapter 2 with another interesting case, and the case is styled Garcetti, and I'm not sure how it's pronounced, but I'm going to take a guess, is Celebus. And the facts of the case are Richard Celebus was a assistant state attorney in Los Angeles County. And let me explain, in a criminal prosecution, when the state attorney receives information from the police of a crime being committed, the police officer files what's called a charging affidavit. And in this affidavit, under oath, the police officer swears to the truthfulness and accuracy of the facts alleged in the affidavit. And in reviewing one of the charging affidavits filed by a deputy sheriff in Los Angeles County, Mr. Celebus discovered that there were some inconsistencies in the affidavit, and that many of the statements by the deputy were inaccurate. He brought this to the attention of his bosses at the state attorney's office. He had numerous meetings with members of the state attorney staff and continued to state that the individual charged with the crime the case should be dismissed against him, that the affidavit was fraudulent, and that he should not be charged with the crimes he's accused of. Mr. Celebus continued to insist on this, and eventually he was fired from his job as assistant state attorney. He filed a suit claiming wrongful discharge and also alleging that his First Amendment rights had been violated, that his freedom of speech had been curtailed by the activities of the state attorney's office. The court looked at the facts and, again, like with the other cases, determined that he really had no legal right to bring this to the attention of his bosses, that there really is no protection for a whistleblower in these situations. And the interesting part of the case is that, unlike the other two cases we discussed where they were private individuals, this was an individual who was a public servant. And so the details of the case are a little different. And again, the result's the same. He was performing his official duty, and his termination was legal and did not violate any of his First Amendment rights or really any of his personal rights. Well, we're going at that we're going to conclude the week 2 live meeting.